Good afternoon. Today, our group are going to present topic 2, Regulation of the Securities Industry. Our group member are SB Law. Today, I will going to present the overview of the law. Firstly, the law in Malaysia. The main sources of Malaysian law are as follows. The Federal Constitution established a constitutional monarchy and a federal system of government. The Parliament functions under this written constitution and is governed by it. Constitutional provisions limit the Malaysian Parliament's law-making powers. The Parliament amends the constitution by a two-thirds majority vote of both chambers of Parliament. All 13 states comprising the Federation have individual constitutions which provide for a single-chamber legislative assembly in each state. Federal laws made by Parliament, state laws made by state assemblies. Federal and state subsidiary legislation, also known as subordinate legislation, delegate legislation. This is made up of rules and regulations enacted by an authority under powers conferred on it by a statute. Common law. Next, principle of English law, suitable to local circumstances. Malaysia adopted English law so far as it was suitable to local conditions. English law was adopted indirectly because it was applied by the judiciary to cases that came before them. In other instances, there was statutory authority for the introduction of English law that was suitable to local conditions in the absence of local laws. For example, lawyer charters of justice. Next, Islamic law, which is only applicable to Muslims and is administered in the Sharia courts. The power to administer Islamic law is primarily that of the states, except for the federal territories of Kuala Lumpur, Labuan, and Putrajaya. Next, the legislative process. Legislation refers to laws made by a person or body, which has the power to make law in Malaysia. Laws made by the Parliament may apply throughout the country or even extra-territorially, but laws enacted by the state can only apply to that state. A federal law is referred to as an act. A state law is called an enactment, except in Sarawak, where it is called an ordinance.
Next, we are going to discuss about the common law. Common law, as opposed to statute law enacted by legislature, is judge-made law or precedent. A binding precedent is a judgment of a decision of a court of law cited as an authority for deciding a similar set of facts. A court is bound by decisions of a superior court where the superior court had decided a case in the same area of law and on similar facts. The resulting common law is naturally Malaysian, although principles of English law may have found their way into the precedent established by the courts. The legislation which affects the securities industry are Securities Commission Act 1993, SCA, Capital Markets and Services Act 2007, CMSA, Securities Industry, Central Depositories, Act 1991, SICTA, and Companies Act 1965, CA. The SCA, CMSA and SICTA are collectively referred to as the securities laws under Section 2 of the SCA. Apart from the four acts, subsidiary legislation such as regulations, orders and guidelines issued by the SC supplement the regulatory requirements of the securities industry. The securities industry have specific laws because specific laws are required to regulate the securities industry, primarily due to the distinct nature of securities themselves, which are different from other types of properties or assets. Besides, one of the primary objectives of securities regulation is to ensure the accurate and timely flow of information to the investing public. The Malaysian Capital Market Regulatory Framework has adopted and benchmarked against the universal standards set out by the International Organization of Securities, IOSCO. The three key objectives of securities regulations are the protection of investors, ensuring that markets are fair, efficient and transparent, and the reduction of systemic risk. There are three functions of regulation which are to define the key features of the capital market system and the role of the securities market institutions, including the development of new types of market activities, to steer market participants towards the adoption of best practices, to create disincentives against behavior that would be detrimental to the market. Next, we proceed to the approach to regulation of stock markets in Malaysia. The regulation of the financial markets has been undertaken in a more streamlined fashion in recent times following the establishment of the SC in 1993 under the SCA. The SC is the principal regulator of the capital market, with Bank Negara Malaysia and the Companies Commission Malaysia, CCM, playing supplementary roles specific to areas within their respective regulatory jurisdictions. The securities industry regulatory framework in Malaysia has shifted from being merit-based to disclosure-based. This progression was considered necessary for the Malaysian capital market to become more efficient and to develop into a sound and credible market of international standing. In simple terms, the merit-based regulation requires any issue or offer of new securities to be subjected to a review of their investment merit by regulators, who may prohibit an offering of such securities if they were judged not to be fair, just and equitable. It is a paternalistic attempt to improve fairness between sellers and buyers of securities in the capital market, as well as to shield public investors from the risks involved in acting on impulse. On the other hand, a disclosure-based regulation system is one in which access to the public securities markets for issuers is conditional upon providing full and accurate disclosure of relevant information in accordance with parameters established by the securities law and regulations. It focused more on the protection of potential investors by ensuring that the information disclosed is sufficient, true and timely. Under a disclosure-based regime, the role of the regulator is to ensure the incentives and structure of the market is consistent with efficiency, fairness, and safety. Firstly, we will explain about the Securities Commission. Securities Commission, or SC, is officially established on 1 March 1993 under the Securities Commission Act 1993. Prior to that, securities regulation in Malaysia was governed by Companies Act 1965 (AMP), Securities Industry Act 1973. The mission of this body is to promote and maintain fair, efficient, secure and transparent securities and future markets, and to facilitate the orderly and development of an innovative and competitive market. The SC comprises of 9 members, who must be appointed by the Minister of Finance, that is a chairman, who shall be an executive chairman, a deputy chief executive, 4 members representing the government, and 3 other persons. The function of the SC as listed under S.15 of the SCA are as follow: to advise the Minister on all matters relating to securities and futures industries, to regulate all matters relating to securities and futures contracts, to ensure that the provisions of the securities laws are complied with, to regulate the takeovers and mergers of companies, to regulate all matters relating to unit trust schemes, to be responsible for supervising and monitoring the activities of any exchange holding company, exchange, clearing house and central depository, to take all reasonable measures to maintain the confidence of investors in the securities and futures markets by ensuring adequate protection for such investors, to promote and encourage proper conduct amongst participating organizations, participants, affiliates, depository participants and all licensed or registered persons of an exchange, clearing house and central depository, as the case may be, to suppress illegal, dishonorable and improper practices in dealings in securities and trading in futures contracts, and the provision of investment advice or other services relating to securities or futures contracts. To consider and make recommendations for the reform of the law relating to securities and futures contracts. To encourage and promote the development of securities and futures markets in Malaysia, including research and training in connection thereto. To encourage and promote self-regulation by professional associations or market bodies in the securities and futures industries, to license and supervise all licensed persons as may be provided for under any securities law. And lastly, to promote and maintain the integrity of all licensed persons in the securities and futures industries. Now, let's move on to Capital Markets and Services Act 2007. It came in effect on September 28, 2007 and repealed the SIA and the FIA. It consolidated the provision of the SIA, FIA and the fundraising provisions contained in the Part 4 of the SCA. The CMSA accords greater protection to investors by enhancing the SC's power to take civil action and administrative action, allowing the SC to recover 3 times the amount of losses through civil action for a wider range of market misconduct including market manipulation, requiring application monies of sophisticated investors to be held on trust in fundraising exercises, enhancing the standards of trustees for debenture holders, extending investor protection provisions to clients of financial institutions. The second regulatory body in Malaysia is Bursa Malaysia. It is an exchange holding company approved under S.15 of the CMSA. It operates a fully integrated exchange, offering the complete range of exchange-related services including trading, clearing, settlement and depository services. Bursa Malaysia's group of companies consists of Bursa Malaysia Securities Berhad, Bursa Malaysia Derivatives Berhad, Bursa Malaysia Securities Clearing Berhad, Bursa Malaysia Depository Berhad, Bursa Malaysia Derivatives Clearing SDN BHD and Labuan International Financial Exchange Incorporated. Bursa Malaysia is the frontline regulator of the Malaysian capital market and has the duty to maintain a fair and orderly market in the securities and derivatives that are traded through its facilities. As an integrated exchange, Bursa Malaysia also has the duty to ensure orderly dealings in the securities deposited with Bursa Malaysia, and orderly, clear and efficient clearing and settlement arrangements for transactions cleared and settled through its facilities. Bursa Malaysia has issued various sets of rules to stipulate the requirements that need to be met by the regulated entities either upon admission and/or on a continuing basis. It administers and monitors compliance with these rules and takes strict, prompt and objective enforcement action for breaches of these rules. Its objectives is to discharging its statutory duties, are investor protection, transparency, high standards of conduct and governance, market integrity and that all relevant persons can participate in our market with confidence.
Next is Bursa Malaysia Security Berhad, BMSB. So for the simple intro of BMSB is, it provides, operates and maintains Malaysia Securities Exchange and enforce listing requirements, disclose requirements, and standard to maintain by public listed company. So the objectives of BMSB is ensure secure, fair, and orderly trading environment, ensure adequate protection of investors, and effectively monitor activities of brokers. The rule of BMSB is prescribe conduct and procedures through which BMSB monitors the affairs of its participants, and self-regulatory process constitute a flexible and wide-ranging system and surveillance and control of the participants. Last is preserve the integrity of the marketplace and to inspire confidence in the industry. The responsibility of BMSB is take disciplinary action on participants, manage accounts, report and supply of information by participants, and handle different complaints and disputes. So what is the participantship in BMSB? Based on 301.2 column 1 of rules of BMSB, no person can access to the market or facilities organized and maintained by exchange, or be entitled to describe himself as participating organization of exchange unless it has been registered as participating organization. So what is the requirement? The company must incorporate or establish in Malaysia, hold a valid capital market service license, satisfy the financial requirement, fulfill the capital adequacy and other requirements. And the rule of BMSB also prescribe some rules that govern the conduct of participating organization. So the last part of BNSB is amendments to rule of BNSB. So rule can amended or repeat by the SC and must comply with requirement of Capital Market and Service Act 2007. And the change of rule which affect right and privilege of participants must be approved by an ordinary solution or the participants and the SC, other which the SC must approve the change. So the next is Bursa Malaysia's Depository Sdn Berhad (BMD). So the simple intro of BMD is it wholly owned subsidiary of Bursa Malaysia Berhad, and it operates and manages scriptless electronic settlement process of the central depository, which is the Securities Industry Act 1991. So it set out the duties, rule, relate, and requirement of authorized depository agents and authorized direct members. So what is the SICTA? SICTA is set out the provision for the establishment of a central depository and the duties of a central depository. So the company which propose to establish and maintain a central depository must apply to Minister of Finance in writing under the SITA for approval. So the rule of central depository is a copy of rule applicable to the central depository must accompany the application for its establishment. The approval will not be granted by minister unless the rule make satisfactory provision for the matters specific in S.5, column 1, column B, SITA.
Next, we move to Bursa Malaysia Securities Clearing SDN BHD. First, we learn about the Memorandum of Association. Bursa Malaysia Securities Clearing SDN BHD is owned by Bursa Malaysia Berhad. It was set up in 1984 and as a centralized clearing house. There are three objectives for Bursa Malaysia Securities Clearing SDN BHD set out in Memorandum of Association. Bursa Malaysia Securities Clearing SDN BHD need to provide clearing participants with facilities for clearing contracts between them and for delivering stocks and securities. However, it also need to maintain facilities for the custody of scrips on behalf of clearing participants in particular. In addition, Bursa Malaysia Securities Clearing SDN BHD need to make, amend and repeal bylaws for the management and control of its affairs. The rules of Bursa Malaysia Securities Clearing SDN BHD are binding on clearing participants and can be amended with the approval of the SC. The rules cover the general rules, clearing participantship, disciplinary action, default rules and clearing and settlement. Furthermore, we discuss about the central bank, which is Bank Negara Malaysia. Bank Negara Malaysia was set up in 1959. It acts as the licensing and regulatory body banks and other financial institutions. However, it also provides the stimulus for the expansion and growth of the country financial sector. Lastly, we learn about Companies Commission of Malaysia. Companies Commission of Malaysia is a statutory body that regulates matters relating to corporations, companies and business. The function for Companies Commission of Malaysia is to enhance and promote the supply of corporate information under any of the laws administered. However, it also helped to create and develop a facility. In addition, Companies Commission of Malaysia also have the power to call for information, conduct inspections, investigations and call for persons. It also to enforce the filling with Companies Commission of Malaysia and to register company and corporation by registering the memorandum and articles. That's so from us. Thank you.